This is Colin O'Keefe, and today on LXBN TV, we are discussing a somewhat ridiculous case that recently went before the Washington Supreme Court, in which a Burger King employee spit on a police officer's burger. Joining me to explain the facts of the case and its impact is Nick Kampars of Davis, Wright, Tremaine, and their hospitality law blog. Nick, first, can you give us the details here? What are the facts of the case, and how did the court rule?
The plaintiff in the case is a deputy sheriff in Clark County, Washington, which is located right across the Columbia River from Portland. The officer was driving his marked police cruiser through the drive-thru of a Burger King restaurant in Vancouver when he described feeling an uneasy feeling after he departed the drive-thru. He pulled his police cruiser off to the side of the road a short while later and observed, after he removed the top of the hamburger, what appeared to be spit on the hamburger patty. Sure enough, later DNA testing confirmed that the substance was saliva and that the saliva belonged to one of the employees at the Burger King restaurant. Well, Officer Bilsma then filed a lawsuit against Burger King and the franchisee owner of the Burger King in Vancouver, Washington. He asserted claims of products liability and negligence, and he sought emotional distress damages as a result. He claimed that he suffered from food aversion, vomiting, nausea, and sleep deprivation ever since the incident at the Burger King. Well, the district court judge dismissed the lawsuit on Burger King's motion for a judgment on the pleadings, determining first that Washington State's product liability statute applied, and secondly, that it did not permit claims where only emotional distress damages were alleged. After dismissing the case, Officer Bilsma appealed to the Court of Appeals for the Ninth Circuit, which then certified the question to the Washington Supreme Court. That question being, may a plaintiff assert a claim under Washington's product liability statutes when only emotional distress damages are alleged? On January 31st of this year, the Washington Supreme Court answered in the affirmative. They said, yes, in fact, a plaintiff can make a claim under Washington's product liability statute so long as the emotional distress damages that are alleged are objectively reasonable and they are exhibited by objective symptomatology, meaning there is some measure of the symptoms that are caused as a result. So in this case, the food aversion, the nausea and vomiting would qualify.
Interesting. So, and second, what impact does this case have? Just how big are the implications when the court rules that there doesn't need to be kind of the traditional physical harm as a result of contamination?
It's uncertain. The state certainly, the case certainly only interprets Washington statute, which is unique compared to uniform products liability statutes. But for restaurateurs and food producers in the state of Washington, it's certainly plausible that this decision opens up a new class of plaintiffs who may potentially assert food contamination claims on the basis of this ruling, and more likely will open up additional claims when cases are already brought in the food contamination area or outbreak area, that there is some emotional distress separate from any physical injury. So I guess the road is uncertain, but it sure will be an interesting ride based on the latest decision from the Washington Supreme Court.
Absolutely. This is an interesting one, and it only makes sense that if you spit on somebody's burger, you stand to be sued for it. So it'll be interesting to watch and see how this is applied again in the future. Again, that was Nick Kampars of the Hospitality Law Blog and Davis, Wright, Tremaine. For his post on the case, be sure to visit dwthospitalitylaw.com. And for curated commentary from the LexBlog Network's thousands of authors, along with more LXBN TV interviews, visit us at lxbn.com. Thank you, Nick.
Thank you, Colin.